Good evening, everyone. We're here for part 4 of the Conen, and we're going to stay with the Emer de Vattel and the legal word format for this go around also. A lot of what Vattel put out in the Law of Nations can be used to tie much of the different government types together, as well as show how any government type can or could be truly of the people. It can also be used to show why virtually all government types fail to be of the people. But put in its simplest words, most fail to be of the people because the people fail to keep hold of their government by means of the deception used by their elected representatives. In other words, we the people trust too easily those we elect to represent us. So let's start with some more of the battle. All citizens who form a political society reciprocally engage to advance the common welfare and, as far as possible, to promote the advantage of each member. Every good citizen sees that the strength of the state is really the advantage of all and not that of a single person. We've seen already that every political society, now political party is a part of a political society, must necessarily establish a public authority to regulate their common affairs, to prescribe to each individual the conduct he ought to observe with a view to the public welfare, and to possess the means, of procuring obedience. This authority essentially belongs to the body of the society, but it may be exercised in a variety of ways, and every society has a right to choose that mode which suits it best. The fundamental regulation that determines the manner in which the public authority is to be executed is what forms the constitution of the state. In this is seen the form in which the nation acts in quality of a body politic, how and by whom the people are to be governed, and what are the rights and duties of the governors, or in our case the elected, society, an association or company of persons, generally unincorporated, united together by mutual consent in order to deliberate, determine, and act jointly for some common purpose. In a wider sense, the community or public, the people in general. And these are legal definitions now. Political party, a number of persons united in opinion and organized in the manner usual to the then existing political parties. An unincorporated voluntary association of persons sponsoring certain ideals of government or maintaining certain political principles or beliefs in public policies of government, not a governmental agency or instrumentality. Political, pertaining or relating to the policy or the administration of government, state, or nation. Pertaining to or incidental to the exercise of the functions vested in those charged with the conduct of government, relating to the management of affairs of state, as political theories of or pertaining to exercise of rights and privileges, or the influence by which individuals of a state seek to determine or control its public policy, having to do with organization or action of individuals, parties, or interests that seek to control appointment or action of those who manage affairs of a state. Now back to Vattel. The laws are regulations established by public authority to be observed in society. All these ought to relate to the welfare of the state and of the citizens. Note, we'll take a brief look at the three types of law without going into much detail, as legal meanings will be provided. Political laws, fundamental laws, and civil laws. The civil laws, regulations, are those that regulate the rights and conduct of the citizens among themselves. Political laws, the regulations again, are based on the public welfare. Fundamental laws, again regulations, are those laws which determine how the constitutional laws of the state are to be exerted. Political law, legal definition. That branch of jurisprudence which treats of the science of politics or the organization and administration of government. Fundamental law. The law which determines the constitution of government in a state and prescribes and regulates the manner of its exercise. The organic law of a state, the Constitution. Civil law. Civil law, and Roman civil law are convertible phrases, meaning the same systems of jurisprudence. That rule of action which every particular nation, commonwealth, or city has established particularly for itself, more properly called municipal law, to distinguish it from the law of nature and from international law. Municipal law, not the law of a city only, but the law of a state. In contradistinction to international law, it is the law of an individual state or nation. It is the rule or law by which a particular district, community, or nation is governed. That which pertains solely to the citizens and inhabitants of the state and is thus distinguished from political law, commercial law, and the law of nations. Modern and narrow connotation, it means those laws pertains to towns, cities, villages, and their local government. Regulation, the act of regulating, a rule or order prescribed for management of government, a regulating principle or precept. Rule of order prescribed by superior or competent authority relating to action of those under its control. International law, the law which regulates the intercourse of nations, the law of nations. The customary law which determines the rights and regulates the intercourse of independent states in peace and war. Public international law is the body of rules which control the conduct of independent states in their relations with each other. Private international law is that branch of municipal law which determines before the courts of what nation a particular action or suit should be brought and by the law of what nation it should be determined. Rule, as a verb, to command or require by a rule of court, as to rule the sheriff to return the writ, to rule the defendant to plead, to settle or decide a point of law arising upon a trial nisi pries, and when it is said of a judge presiding at such a trial that he ruled so and so, it is meant that he laid down, settled, or decided such and such to be the law. Rule is a noun. An established standard, guide, or regulation, a principle or regulation set up by authority, prescribing or directing action or forbearance as the rules of a legislative body, of a company, court, public office, of the law, of ethics, a regulation made by a court of justice or public office. Nius prius. The Nius prius courts are such as are held for the trial of issues of fact before a jury and one presiding judge. In America, the phrase is familiarly used to denote the forum, whatever may be its statutory name, in which the case was tried to a jury, as distinguished from the appellate court. Appellate court, a court having jurisdiction of appeal and review, a court to which causes are removed by appeal, certiorari or error, a reviewing court, and except in special cases where original jurisdiction is conferred, not a trial court or court of first instance. Certiorari, to be informed of, to be made certain in regard to, the name of a writ of review of or inquiry. Certiorari is an appellate proceeding for re-examination of action of inferior tribunal or as auxiliary process to enable appellate court to obtain further information in pending cause. Now, this is one of those words that has much more available, but following will be enough to understand the word and how it is used in several states. Originally, in English practice, an original writ commanding judges or officers of inferior courts to certify or to return records or proceedings in a cause for judicial review of their action. In Florida, the writs of certiorari are in use are the common law writs, the statutory writ to review judgments of civil courts of record. The rule certiorari to review interlocutory appeals in equity. The rule for supplying omitted parts of records on appeals or writs of error. In Massachusetts, it is a writ by the Supreme Judicial Court commanding inferior tribunal to certify and return its records in a particular case that any errors or irregularities which appear in the proceedings may be corrected. In Texas, the ordinary office of writ is to perfect a record on appeal. In some states, the writ has been abolished by statute so far as the common law name is concerned, but the remedy is preserved under the new name of writ of review. Rule of law, a legal principle of general application, sanctioned by the recognition of authorities as usually expressed in the form of a maxim or logical proposition, called a rule. because in doubtful or unforeseen cases, it is a guide or norm for their decision. Rule is one of those words that has various meanings and could be a subject unto itself, and perhaps we will do that at some time in the future. A little more from Vattel. Besides, the laws and constitutions of different states must necessarily vary according to the disposition of the people and other circumstances. In the law of nations, we must adhere to generalities. And here's a good place to stop to make sure we keep it short. So as always, this was a small amount and it leaves much for us to get into, and we will a little at a time to help prevent information overload or even burnout. As said before, if you spend too much time digging into all this at once, you could experience information overload or even burnout. And again, if you have found this to be beneficial in any way, then please visit and like my YouTube and Rebel channels. As always, remember to share across all your social platforms, and most importantly, with family and friends in other countries, as this is a global war. Blessings and much gratitude to all of you.